He was never there for my child. It's more to take raising a child than finance.
So is it a hardship for you to repay the $13,000?
It's not, sir, but why should I be obligated to pay something that I feel like I didn't take?
Gotcha, bitch.
Welcome to Male Reality Lessons, where topics are reviewed and discussed as iron sharpens iron. On Male Reality Lessons today, we're going to talk about child support. In respect to child support payments, we know mothers typically have no problem bringing up the issue to the courts when child support is not being paid or is underpaid. But on today, we're going to talk about some of the unusual cases when there is an overpayment. Every state operates a little differently when it's time to conclude the man's obligation for payment. Some require you to initiate an action, others typically just stop it after informing both parties that it will conclude on the child's 18th or 21st birthday, depending on the state. But in today's case, we're going to see what happens when the overpayment continues to be paid and the mother plays dumb.
All right, you're both officially under oath. I'm going to go ahead and let Mr. Starr call you both as witnesses. The state will have the opportunity to cross-examine. And again, at the end of the hearing, ma'am, if you have anything else you think I need to know that didn't come out during your general testimony because you're a pro se litigant, I will allow you to testify to it in a narrative form, so long as it's relevant. So at this time, Mr. Starr, you can call your first witness, please. Thank you.
I'd like to call my client, Mr. Guy, please.
Yes, sir.
Okay,
Mr. Guy, state your full name for the record, sir.
Stanley Allen Guy.
All right, you may proceed.
All right, and Mr. Guy, will you state your son's name in this case?
Zabrion DeJour Williams.
Okay, and did he turn 18 years of age on December 13th, 2020?
Yes, he did.
And did he graduate high school in May of 2021?
Yes, sir.
And to your knowledge, since your son graduated high school, have you continued to have your wages garnished for the purposes of child support?
Yes.
Okay, and was the last child support payment you made, did that occur in September of 2022?
Yes.
Okay. Now, do you remember uploading to our case management software a document called a financial activity report that you received from the Attorney General's office?
Yes, sir.
All right, to your knowledge, did you alter that document in any way?
Not at all, sir.
Okay. Your Honor, I'd like to submit that document into evidence. I emailed it to you and I believe the Attorney General, but they should have it as well.
You emailed it to Belinda?
Yes, I did.
All right.
State has no objection, Your Honor.
Okay, I must have left it on the bench. Can you go grab it for me, please? Yeah, I'm sorry. I had to move off of the bench and move over here, so.
There's also
it was underneath.
Okay, there's also the state disbursement record. We're going to just enter that into the evidence as well. It should
I've
be
got it here.
confirmed.
Just a second here. All right, here we go. And so I'm remarking this is respondent fathers number 1. All right, folks, I know you can't see it very well, but this is the respondent fathers number 1. It is the accounting of the child support that was paid to the state disbursement unit in this case. Is there any reason this should not come into evidence at this time, Mr. Diamond?
No, Your Honor.
All right, Ms. Williams, is there a legal reason this shouldn't come into evidence, ma'am?
No, Your Honor.
All right, respondent fathers 1 is admitted. You may proceed.
All right, Mr. Guy, did you see at the end of that document, the Attorney General's office states that you overpaid child support by $13,476.88?
Yes, sir.
Does that amount seem accurate to you?
Yes, sir.
Okay. Do you also remember submitting to our office a document titled Texas Child Support Disbursement Unit Payment Record?
Yes, sir.
Okay, and to your knowledge and belief, was that document altered in any way?
Not at all, sir.
And do you believe the information on that document is correct as well?
Yes, sir.
All right, I'd like to submit that as petitioner's exhibit 2, Your Honor.
All right, I'm marking this as respondent fathers, RF2.
All right, Mr.
All right.
Go ahead.
Any objection to RF2 coming to evidence at this time, Mr. Diamond?
No, Your Honor.
All right. Ms. Williams, is there a legal reason that this information should not come before the court this time?
No, sir.
All right. RF2 is admitted. You may proceed, Mr. Starr.
Okay. Since your son graduated high school, Mr. Guy, has Ms. Williams paid you back any of the overage amount of child support?
No, sir.
Okay, would you like the court to award you a judgment, $13,476.88, to make up for the excess amount of child support that has been garnished from your check?
Yes, sir.
All right, and would you like the court to award you attorney's fees since you had to hire me to get this money back?
Yes, sir.
Is there anything else you think the court should hear today, Mr. Guy?
No, sir.
I have no further questions for this witness.
All right. Mr. Diamond.
No questions, Your Honor.
All right. At this time, Ms. Williams, technically you're your own lawyer. I always have pro se litigants, if they have questions, they have to run them through me because I want to make sure that they're relevant. So at this time, ma'am, as your own legal representative, do you have any questions, Mr. Guy?
No, I don't have any questions, sir, but I do have a statement.
All right. Well, that's at the very end, ma'am. Thank you.
Okay.
All right. All right. So, Mr. Starr, you can call your next witness, please.
All right, I'll call Ms. Williams, please.
All right. Ms. Williams, state your full name for the record.
Bertina Levette Williams.
If you're enjoying the video, please take a moment to like, share, and subscribe to Male Reality Lessons.
Bertina Levette Williams.
All right, thank you, Ms. Williams.
Starr.
Okay. How old is your son now, Ms. Williams?
He's 20 years old.
All right, and when did he turn 18?
He turned 18 in, I think it was 2020 of December 13th.
Okay. And did he graduate high school of May of 2021?
Yes, he did.
Okay. Now from September 7th, 2011 to September 27th, 2022, did you receive child support payments for your son?
I did, sir.
Okay. And after your son graduated high school, did you continue to receive those child support payments?
I did.
Now you see now, you done fucked up, you know that, don't you?
All right. Have you returned any of the excess money since your son graduated high school to Mr. Guy?
No, I have not, sir.
That's a damn shame.
No further questions, Your Honor.
All right. Mr. Diamond.
Yeah. What are the reasons why you didn't return the money, Ms. Williams?
The reason I didn't return them, sir, in December of 2020, I was notified by the Texas Child Support, and they told me that my case was no longer a court-ordered case. And they also told me that my son's father was always also notified. So how did I know he wasn't doing that on his own to rectify or compensate for what he wasn't doing for my child?
Maybe people don't understand the definitions of these words.
I'm sorry. So the point you're trying to make is that his contribution to your son growing up was insufficient, and this was maybe a way of trying to make things right?
Absolutely, sir.
What?
Child support only started in 2011. From 2011 before, I was doing that on my own. He chose when to take care of my child.
So it sounds like it's an equitable argument that child support didn't go back far enough when it was initiated.
It did not. We have 9 years where I did this solely on my own. I mean,
Objection, non-responsive. Mrs. Meredith.
All right. Here's the deal, ma'am. Yeah, that's not going to fly. Again, this is kind of straightforward. Is there any other reason? I'm sorry. I can't go behind the order of 2011, ma'am. So is there any other reason that you're alleging that happened after 2011 that you should be granted some type of credit for, as far as the overpayment is concerned, ma'am?
absolutely, sir.
All right. What's the reason, ma'am?
Emotional, physical needs. I
I
mean,
beg your pardon. I beg your pardon.
he was never there for my child. It's more to take raising a child than finances.
Yes, ma'am.
I mean, the medical bills, the dental, all of these things.
Okay, ma'am.
May I ask the witness a few more questions, Your Honor?
Go right ahead.
Are you in good health currently, Miss Williams?
I am, sir.
And do you have other family members who have health issues?
I do, sir.
Are they close family members?
Sir, I do. We just lost an auntie just Saturday. Yes,
So I take it you help pay for some of the funeral costs?
I do. I have custody of my nephew as well. I lost my sister. I'm raising him as well.
How old's your nephew?
He's 11.
Okay, here's what I'm getting at. You would have to show that it's a hardship for you to repay this $13,000. So is it a hardship for you to repay the $13,000?
It's not, sir, but why should I be obligated to pay something that I feel like I'm...
You can't make this shit up. You can't make this shit up. Y'all heard it.
Okay, here's the deal, ma'am. That you feel is not going to meet the legal standards for me to not order this, ma'am. Again, I've got to have some reason at law. I know you're not a lawyer, but you didn't retain counsel. I gave you the opportunity to do so, and I've got to hold you to the same standard. And right now, I'm not hearing anything that's going to get you to a legal standard of giving some type of forgiveness. I'm going to let the states continue to ask questions, but again, you can't. I've known people for years who they don't do it. They don't have a darn thing to do with their kids. All they do is pay the child support. And I've been saying for years, the only thing I can order is child support. I can order it based on what the law says I'm supposed to do, and I can't make somebody be a parent. That's not within my purview. So unless there's a legal reason, ma'am, that the money, and again, I know you're not a lawyer, but I got to hold you to that standard. Unless there's a legal reason for me not to order it, ma'am, then I'm probably having to look at orders. So is there a legal reason that you know of, ma'am?
It's not, sir.
The party's over. They say that all good things must end. Call it a night. The party's over.
Okay. All right. You may proceed, Mr. Diamond.
I don't know if there's much more I can add at this point, Your Honor.
All right, then.
Pass witness, sir.
Okay. Anything on redirect, Mr. Starr?
No further questions, Your Honor.
All right. First off, I got to ask, obviously, we're all sitting in here. I don't think, does the state have any witnesses that the state wishes to call at this time?
No, Your Honor.
All right. Ms. Williams, do you have any witnesses you wish to call at this time, ma'am?
No, Your Honor.
All right. At this time, I'll listen to closing arguments, and I'll start with you, Ms. Williams, again. Why shouldn't the court do what the court has been requested to do by the Christian firm in this matter? So, ma'am, thank you. This is your time to make a statement, another statement on the record, ma'am. Thank you.
No further comments, sir.
All right. Mr. Starr?
Yes, Your Honor. I just want to reiterate the law I stated in my opening remarks. 154.012 of the Family Code states that if you make a finding that someone has paid in excess of child support, not only can we bring suit to collect for the overage, but Section B states that if the obligee has not repaid the overage, the court shall order attorney's fees and court costs be paid in addition to the overage. You heard testimony from my client saying that there is an overage. The OAG confirms that there is an overage. He said my numbers were correct. And Mr. Guy has said he's not been paid back. And Ms. Williams has agreed with that assessment that there is an overage and she has not paid it back as well. The overage is $13,476.88. And attorney's fees before this hearing began are $5,808. That would make the total judgment, if my math is correct, $19,284.88. And we would just like to request that amount in our favor, Your Honor.
Good. All right, folks. Again, this is kind of a straight out accounting one. What I'm going to go ahead and do, I'm looking at having to find, obviously based under the Texas Family Code, that the money that it appears to be uncontroverted, that the funds were paid to Ms. Williams, and they were in excess of the child support amount after the date of graduation and the child turned 18. So the court will reduce the judgment that unpaid amount.
Here are my final thoughts. It behooves you, if you're on child support, to check your local and state laws regarding when it terminates what needs to be done to ensure it terminates and ensure that your checks no longer are garnished. At the end of the day, it's always going to be your responsibility to do the follow-up, because you know the alternate party typically is not going to render you any aid. And it's quite unusual that the situation that occurred here turned out in the gentleman's favor. Don't know about all states, but I'm sure if you don't do your due diligence, that money may evaporate into the ether. But kudos to him. Yet, I want to hear from you in the comment section. Give me your thoughts on this subject or any other topic you would like to discuss on Male Reality Lessons. As always, I want to thank you for watching. Please subscribe and have a good day.